Please come to order. Please turn off your cell phones. It is a measure of the importance attached by the Senate to our present bill, Senate Bill number 2408, also known as the Bangsamoro Basic Law, that this bill has been assigned to no less than 3 committees. Normally in the Senate, and I presume in the House, a bill is assigned to only 1 committee. An exception is when it is assigned to a 2nd committee. So this is a super exceptional proceeding we are taking for this special bill because it has been assigned to 3 committees. The 2 other committees are the major committee, the Committee on Local Government, headed by Senator Ferdinand Marcos Jr., who I understand is coming. The 2nd committee is the Committee on Peace, Unification, and Reconciliation, headed by Senator Teofisto Gingona Jr. And we are conducting this as chair of the Committee on Constitutional Amendments. Basically, our issue is what price is the Philippine government willing to pay to achieve peace and reconciliation in the troubled area of our country called Mindanao. In the present hearing, we have structured the major issues raised by the bill, only with respect to constitutionality, into 4 main topics. The first topic is legislation versus charter change. The second topic is checks and balances in the national government versus none in the BBL. The third topic is sovereignty versus the concept of the substate. And the fourth topic is the concept of territorial integrity versus the functional division of those territories. What we have done is introduce a debate format. Normally, in a public hearing like this, we have a resource panel, and each panel, whether they are pro or con, each panel member is called in any order, whether he is pro or contra the measure. So what we get is a generalized, very generalized debate, and no specific debate on particular topics. We have changed that by this debate format such that the first topic, for example, will first be dealt with by 1 topic for the pros and 1 topic for the contras, and then we go to the second topic, and then we pick the next 2 partners in debate. So that way we are focused on exactly what is being debated upon. We are happy to acknowledge the appearance of the chair of the Committee on Peace, Unification, and Reconciliation, Senator Gingona, whom I mentioned earlier. So this will be the first hearing. Again, this is also notable because normally a committee hearing takes only once. But this time we will have 2 hearings, today Monday and next Monday, February 2, but always in pairs. So let me just explain what we mean by these 4 topics. As you know, I have a malady, so I tend to speak very fast, and then I run out of breath. First, the first topic is legislation versus constitutional change. By this topic, we mean, can this BBL, the Bangsamoro Basic Law, which we shall refer to as the BBL, can this BBL, in the form of a bill, after having been passed by its counterpart form in the House, and assuming for the sake of argument that it is passed in the Senate, can it just become a law just in that method, adopting the method of ordinary laws? Is that how facile it will be to get these reforms that we seek so badly for the troubled area? Again, we acknowledge the presence of the chair of the Prime Committee, the Committee on Local Government, Senator Ferdinand Marcos Jr.
Thank you, Madam Chair. Good morning.
So, there is one side that says legislation will be sufficient. We should just treat BBL as if it were an ordinary law. It goes to House, it goes to Senate, and then it goes to a plebiscite. But the other hand argues that the reforms are so deep-rooted and are so drastic in consequences that an ordinary bill process will not do. Instead, we should undergo the process of constitutional amendment or revision. Let's go to the next topic, checks and balances in the national government versus none in the BBL. What we mean here by checks and balances is that today we operate under a presidential form of government where there are checks and balances among the three branches of government. So checks and balances is the distinguishing character of our liberal democracy. However, in the Bangsamoro area, there will be no such checks and balances because instead of a presidential, they will have a ministerial form of government, where, as you know, it is accepted there are no checks and balances between the executive and the legislative, since they form in a sense just one body. That's what we mean. And that's what I think what the proponents mean when they speak of an asymmetrical relationship. The third topic is sovereignty versus the substate. What is sovereignty and where does it reside? It bears further examination because basically this entire report about constitutionality will revolve around the issue of sovereignty. Is sovereignty divisible? Is it like local autonomy, where national government possesses national powers and local units possess local powers? Or is it far from that? Plus, if that is the nature of sovereignty, does it admit of another area in the same territory claiming to be in the same state that is complete as a state if you apply the test of the 1933 Montevideo Convention, where, in classic format, the definition is made: a state is a specific territory with a population enjoying self-government, free from internal control, and capable of instituting relations with other states. If these four traits of the state, as defined by the landmark Montevideo Convention, are present in Bangsamoro, are we not therefore creating what might be called a substate or a less than sovereign state? Are we not therefore creating another state within a state? And we should remember what the Supreme Court told us in one of the more landmark cases concerning local autonomy. There can be no imperium in imperio, but we shall elaborate on that. And finally, the concept of territorial integrity versus the concept of functional division of territories. If we have one territory defined by our archipelagic baselines, parenthetically, the archipelagic doctrine states that the coastline of the Philippines will not be the coastline of the individual islands, but will be a coastline that results if you draw a straight line from the outermost islands around the Philippines. From that archipelagic baseline, we measure, for example, such territories as our 12-mile territorial sea and the 200-mile exclusive economic zone. But if we apply the theory applied in BBL, it might be possible that we shall suffer either or at the same time a diminution and an increase in territory. Will the international community accept this kind of an arrangement, which might be domestically acceptable but might not be acceptable to the rest of the world? So, if there is any question about the topics covered by these subdivisions, just ask me. Let us begin. The first topic is, can we just pass a bill, this Senate bill, as if it were an ordinary law, or do we have to go through the process of constitutional amendment and revision, which will certainly take a longer time, plus will certainly be more acrimonious. The first speaker will be Secretary Teresita Quintos Deles, the presidential advisor on the peace process, and on the other side will be Justice Florentino Feliciano, former Justice of the Supreme Court, former Judge of the World Trade Association World Trade Organization in arbitral tribunal, and I again say, conceivably, the most prominent Filipino practicing law in the planet today. So first we will call Secretary Deles, and then we shall call on Secretary Feliciano. Please pardon me, but I will have to stress that perhaps every speaker can just confine himself or herself to our comments for about 20 minutes so that we can accommodate everybody here and nobody has to come back a second time. Ms. Deles.
Good morning, Your Honors, to the honorable chairs. Thank you for the opportunity to address the Senate again on this matter. We have already attended one hearing once before. Before I read my statement, I would just like to put on record that I am not a lawyer, Your Honors. I'm a simple Bachelor of Arts and certainly have no standing to be on the other side of a table with Justice Feliciano, but I hope having helped to steward this process that our perspective here is put forward. When the negotiations between the government and the Moro Islamic Liberation Front restarted in 2009, we knew that we had a daunting task ahead of us. The Supreme Court's decision to render the contents and the manner by which the Memorandum of Agreement on Ancestral Domain, or MOA-AD, was drafted as unconstitutional and contrary to law weighed heavily on our scale of decision-making. Even more, the immediate repercussions of a botched peace process, the reignition of violence, the many lives and properties lost and horribly affected, the general sentiment of hopelessness were our constant reminders that we cannot take every word, phrase, or statement in any of the political agreements lightly. Thus, we made it our mission to prevent any misstep in forging the comprehensive agreement on the Bangsamoro or CAB, to keep all the provisions therein within the flexibilities of our Constitution and as guided by the Supreme Court ruling in the landmark case of the province of North Cotabato versus Government of the Republic of the Philippines, or the MOA-AD case. Since the government panel under the Aquino administration started, we have conducted 442 consultations across the nation, in keeping with the commitment to make this process inclusive, participative, and consultative. Nowhere in the CAB can the term associative be found, nor any of its features entrenched or alluded to in the peace agreement. We will also not find a single guarantee for charter change to accommodate the CAB. The most accurate that can be said is that this agreement recognizes the right of any citizen of the Republic, including those who are appointed in the Bangsamoro Transition Commission, to propose amendments to the supreme law through the modalities provided in our Constitution. These and more distinguish the CAB from the declared unconstitutional MOA-AD. The draft Bangsamoro Basic Law, or Senate Bill number 2408, the translation of the CAB into a proposed legislation, is one that can be well accommodated by the provisions of our charter. Even as the Constitution is deemed read into any legislation passed by the National Congress, SB number 2408 explicitly guarantees that it will be in consonance with the Constitution, that is in the preamble, and thus its provisions, in case of ambiguity, should be read with the parameters of the 1987 Constitution in mind. The establishment of a parliamentary form of government in the Bangsamoro intends to bring life to the text of the Charter that leaves to the wisdom of Congress the determination of the structure of government for the region, provided only that the executive and legislative branches will be elective and representative of the constituent political units. That is Section 18, Article 10 of the Constitution. The draft BBL, as it gives improved autonomy to the Bangsamoro, continues to honor its place as an integral part of the country, stated explicitly in Section 1, Article 3, whose government remains under the general supervision of the President. That is in Section 3, Article 7. The Bangsamoro Police, Article 11, a unit of the Philippine National Police and is an integral part of the law enforcement functions, remains true to the constitutional prescription of maintaining only one national police under the administration and control of the NAPOLCOM. That is under Section 6, Article 16 of the Constitution. But perhaps the most glaring difference between the MOA-AD, a political document, and Senate Bill number 2408, a proposed legislation, is the operationalization of the constitutional requirement to conduct a plebiscite and allow those provinces, cities, and geographic areas which favorably vote for the BBL to be part of the Bangsamoro. That has been stated in Section 18, Article 10 of the Constitution. In this bill, for the first time, we recognize the spirit of the provision that gives primacy to the consent of the governed in determining their political status by allowing municipalities and barangays, not just provinces and cities, to participate in the plebiscite. We intend to right the wrong committed against the phrase geographic areas when it was all but rendered a mere surplusage in the past legislations. Senate Bill number 2408 proposes many novel changes for the proposed Bangsamoro. As demonstrated, this, however, does not mean that there is no constitutional basis for all of these, or that a mere legislation without charter change can enforce them. We maintain that a closer scrutiny of the provisions of the draft BBL and a more comprehensive understanding, even beyond the textual or traditional interpretation of the words of the Constitution, will bring us to the conclusion that the framers and the people who ratified the Charter had the foresight to entrench a unique setup in the autonomous region, one that respects the peculiar situation in the area, that is not inconsistent with, but is in fact a means to preserve our national sovereignty and territorial integrity under the 1987 Constitution. Thank you, Your Honors.
Thank you very much. And may I please request once more all the members of the resource panel to give their statements, if possible, before you leave these chambers. To my Chief of Staff, Attorney Fatima Panantongan, will you stand up, please, and raise your hand? So, and then, before we continue, it is a pleasure to greet a member of the Committee on Constitutional Amendment, Senator Pia Cayetano, and also a former member of the Philippine Senate who served with much distinction during his term, Senator Aquilino Pimentel Sr., whom, out of courtesy, we invite to join us here since you are a senator all your life. Thank you. Now let us turn to Justice Florentino Feliciano, whom, despite his many concerns, have done honor to our committee by coming here. So, if you don't know your law, will you please just keep quiet or I will lose my temper. Justice Feliciano. Justice Feliciano, when he was just a mere student in Yale University, already collaborated on a worldwide bestseller on the law of the sea, written in collaboration with his professor, and is often our lawyer, our champion for Philippine causes in international litigation. He has just won one of them.
Thank you. Thank you very much, Madam Chairman. I propose to be quite brief this morning, if only because I got the papers somewhat late and I've had to attend to a sick wife. Now, Madam Chairman, I would like to begin by pointing out that the proposed Bangsamoro Basic Law is not just a piece of proposed legislation by the Congress of the Philippines. The proposed BBL, if I may call it that, also constitutes the so-called, quote, comprehensive agreement on the Bangsamoro, close quote, between the government of the Republic of the Philippines and the Moro Islamic Liberation Front. It purports, in other words, to be the result of a prolonged negotiations for peace between the sovereign Republic of the Philippines on the one hand and a group of rebels who happen to be very well informed, very well armed and very well funded. Now, it purports to be the result of agreement, as I said, between two entities, each presumably claiming to be vested with the juridical capacity to enter into agreements which have some binding effect under some system, although unnamed, system of law. Whether viewed as either a bill or a draft legislation submitted to our Congress, or the consequence of an agreement-making process, it must be clear to everyone that the proposed BBL must be consistent with the provisions of the 1987 Constitution of the Philippines. Otherwise, the proposed BBL cannot have any legal effect or consequence as a matter of Philippine law. That's a proposition which I respectfully suggest is self-evident and needs no support for reference to literature. I wish to refer at this point to the statement on Senate Bill number 2408 made by Mr. Justice Vicente Mendoza. In the interest of economy of time and effort, let me say that I agree with all the principal points made by Justice Mendoza in his statement, and will hence avoid elaborating on those points, although making, I apologize in advance, a few minor comments on them. Let me start by saying, in respect of the term territory, as used in both Senate Bill 2408 and the comprehensive agreement on the Bangsamoro, which I will, for brevity's sake, refer to as CAB, it may be noted that one of the essential elements of a state in international law is that of territory of the entity seeking recognition as an independent and sovereign state under public international law. Now, under Philippine administrative law, I need not stress too heavily that our provinces, our municipalities, our municipal districts, etc., also have defined territories as designating the earthly limits of the exercises of their legislative and their law enforcement authorities. The concerns many have over Bangsamoro territory as indicating demands for a separate sovereign state have to some extent been eased by addition of the sentence, and I quote, "The Bangsamoro territory shall remain a part of the Philippines," unquote. But this statement must be given, in my view, a forceful meaning. It is not a window dressing measure. In other words, retention within the territory of the Republic of the Philippines must be real and not merely verbal in character. And that is the problem that many of us have in understanding the draft, both the draft BBL and the comprehensive agreement. If the comprehensive agreement, if we took the statement seriously, is the result of a process that began in the 90s, continuing to the 2000. It's 2015 today. The next important concern that I have is based in Article 3, Section 2D of the proposed BBL, which provision expressly provides for expansion of Bangsamoro territory by the simple resolution of a local government unit or a petition of at least 10% of the voters of a contiguous area asking for inclusion in the territory of the Bangsamoro, plus a, quote, popular ratification, unquote, within such area. In other words, no historical or anthropological basis need be shown justifying absorption into the territory of the Bangsamoro. Further, and this is of extreme importance in my personal view, the structures and the processes set up by existing administrative law of the Republic of the Philippines may be modified or swept away by acts of the Bangsamoro government. This is not something that can be authorized to be done by a statute enacted by the Philippine Congress. Maybe I should repeat this last point. My understanding of the BBL and of the comprehensive agreement is that the Bangsamoro government may change what presently exists under Philippine law in the so-called Bangsamoro territory. If I am wrong, I would be very happy to be corrected. A related point concerns the distribution of governmental powers and functions between, on the one hand, the government of the Republic of the Philippines and, on the other hand, the Bangsamoro government. This distribution needs careful attention. Now, I will start dealing with this by pointing out that the government of the Republic of the Philippines will have, quote, quoting from the BBL, or the proposed BBL, unquote, reserved powers, which include, among other things, defense and external security, foreign policy, citizenship and naturalization, economic agreements with third parties, third countries, immigration, and so forth. Let me stress that once more. The government of the Republic of the Philippines will have what are designated as reserved powers. Next, the Bangsamoro government is designated as having quote, exclusive, please note that, exclusive powers, close quote, including agriculture, livestock, food security, loans with foreign corporations or countries, trade, industry, foreign investment, labor regulation, free ports, the banking systems, education, public utilities operations in the Bangsamoro territory, ancestral domain and natural resources, land management and distribution, Sharia courts and the Sharia justice system, local administration and municipal corporations, education. Please note that these exclusive Bangsamoro powers are all deductions from or reductions of the general sovereign authority of the government of the Republic of the Philippines on this so-called Bangsamoro territory and the population thereof. In other words, these exclusive powers, and it is only in respect of Bangsamoro functions and powers that the term exclusive is used, represent deductions from, reductions of authority that is vested today under our Constitution in the government of the Republic of the Philippines. They cannot be taken from the atmosphere. They have to be taken from what exists under our Constitution and law. And what is it that exists? What exists today is the government of the Republic of the Philippines. If you cut out and designate as exclusive powers and authorities and give that to Bangsamoro government, you necessarily need to reduce the sum total of the authority vested in the government of the Republic of the Philippines. Who has authority to do that? I respectfully suggest, Madam Chairman, that the Senate, nor even the whole of Congress, has authority to do that. It's another division or categorization of authority between the government of the Republic of the Philippines and the Bangsamoro government is concurrent authority. What is covered by this term concurrent authority? Well, things as important as, I will just mention two, private schools, public utilities. Please note that the government of the Republic of the Philippines will have more limited functions and duties than the Bangsamoro government touching the daily lives of the people who live in the so-called Bangsamoro territory. Because it is from the sum total of the sovereign authority or the government of the Republic that what is given to Bangsamoro government necessarily is taken or deducted from. Constitutional amendments will be necessary to put the distribution of powers into effect. Madam Chairman, I think I should stop at this point. Perhaps you will permit questions later on at least to the extent that there are remaining portion of the 20 minutes that you have given each one of us. Thank you, ma'am.
Thank you very much. At this point, we will entertain questions directed to each of the two resource persons who have taken contrary positions on the particular issue we're discussing. But in the meantime, regardless of the position that he has taken today, we would like to express the deep appreciation of the committee for the attendance of Justice Feliciano, considering that his age, plus the fact that he is visibly suffering a malady. And just to add the most persuasive reason, because we have just listened to one of the most brilliant minds in Philippine history, both living and dead. I invite this audience to give him a standing ovation. And now, are there any questions from the senators? Senator Gingona.
Thank you, Madam Chair. Justice Feliciano, clearly you were saying that when the BBL makes changes in the power structure, such as the reserved, the concurrent, and the exclusive powers, you're saying that these are constituent matters and not legislative matters, and that Congress cannot deal with it or has no capacity to pass it in its legislative plenary, legislative authority. But if it was acting as a constituent body, then it could do so. Am I correct?
Mr. Senator, I understand by constituent authority, authority under the Constitution to modify existing structures and processes
in the Constitution,
provided for in the Constitution, or provided for by legislation authorized by or consistent with the Constitution.
Yes, sir.
Yes.
So that would be appropriate.
Excuse me, will you please clarify what you mean by...
If Congress passes this not as legislative, mere legislation, but constitute itself as a constituent assembly, hereby authorized to amend the Constitution, then that would cure the...
Mr. Senator, if by that you mean that Congress would go through the processes of constitutional change presently specified in the Constitution, by all means, no?
By all means.
Yes.
The second point, since the Constitution is a manifestation of the sovereign will of the people, and the BBL, as you pointed out, runs counter to the manifestation of the will of the people, which is the Constitution, would it not be corrected by or ratified if a referendum/plebiscite of the whole country ratifies the BBL? So that can we say this is the Constitution is a manifestation of the will of the people, but since the BBL is ratified by the country as a whole, it is also a manifestation of the will of the people.
Mr. Senator, I would suggest that that point be the subject of a careful clarification. Do not rely upon implied consequences on it. Changing a constitution is serious business and requires careful consideration of the benefits of the people. No, it is not something that you sleep over on a weekend and finish on Monday. Please, that is, and if you look at the difference in the structural differences between what is covered by the Bangsamoro government and what our present administrative law. Remember, our administrative law is very old. It began in the first decade of the 20th century, and as you know, Mr. Chairman, Madam Chairman and Mr. Senator, we are now in the 21st century. At least I feel we are in the 25th century many times. So it is not something that you should imply. You should clarify to the people. And what is remarkable, permit me, and I mean this without anything, at least this old man didn't realize that even the BBL was in the process of negotiation, discussion between the Bangsamoro and the government of the Republic. I can understand your reasons for keeping things under lock and key. It's more peaceful, it's perhaps a little more acceptable to yourselves and a little less hurtful in its impact to each one of you. But the net result is the people are not informed. At least this old guy never even realized that, especially after the decision of the court in the North Cotabato province case, and then you had the MOA AD. The differences between the MOA AD and BBL is something, represents something that must be carefully considered. I suggest that the differences may be more rhetorical than real. Thank you, Chairman.
Thank you, Justice Feliciano.
If there are no more questions from our Senate panel, we should then proceed to the next topic to be debated by two resource speakers.
Madam Chair,
Yes, please.
may I just respectfully request, if it is possible, for us to connect with the statement of Justice Feliciano regarding the constitutionality angle, Mrs. Chairman, Madam Chair.
Yes, does Senator Pimentel mean that you want to say something at this point?
Yes, ma'am, if that
Well,
is possible.
go ahead, please.
Thank you, Madam Chair, and distinguished members of the panel, as well as my colleagues in the resource persons present today. My observations are based on the Senate version of the proposed Bangsamoro Basic Law. The intent of the BBL to bring peace, progress, and development primarily to Mindanao and ultimately to the rest of the country deserves the support of our people, no question about that. But its intent, as borne out by the content, must conform to the Constitution. My comments, therefore, Madam Chair, will deal only with two basic issues that are contained in the proposed BBL. Number one, the proposal under Article 4, General Principles and Policies to install a Bangsamoro government that is parliamentary in form and an electoral system suitable to a ministerial form of government. And the next issue would be on the limitation, part of which has already been pointed out by Justice Feliciano, on the reserved powers of the central government to certain areas. Now, Madam Chair, under the Constitution, the form of government that is ordained is presidential. That is found in Article 7 of the Philippine Constitution. The same Constitution mandates in Section 1 of Article 10 on the local government as a part of the general provisions of the Constitution of Article 10 that the territorial and political subdivisions of the Republic are the provinces, cities, municipalities, and the barangays. There's a second sentence. There shall be autonomous regions in Muslim Mindanao and the Cordilleras, and I want to emphasize the succeeding phrase, as hereinafter provided. We will now just talk about the autonomous region of Muslim Mindanao because that is what is covered by the BBL. It is submitted, Madam Chair, that to allow a part of the country to be governed under a parliamentary form of government when the Constitution itself proclaims that the whole country has adopted the presidential form of government would be, to say the least, incongruous. In Section 18 of Article 10, it is provided that the Organic Act shall define the basic structure of government for the autonomous region, consisting of the executive department and legislative department, both of which shall be elective and representative of the constituent political units. The basic structure of government of the autonomous region then consists of the executive department and the legislative assembly, both of which shall be elective, Mr. President, Madam Chair. Which means, Madam Chair, that this would be contrary to the intent to adopt a parliamentary form of government because, as you very well know, in a parliamentary form of government, it is the legislature that is elected, out of the members of which would come the who would constitute the executive department, Madam Chair. It is thus submitted that the above-quoted article and section of the Constitution validate the thrust of this paper, that the autonomous region envisioned in the Constitution, which the BBL intends to govern, must follow the form of government that is provided for in the fundamental law, and that is none other than the presidential form of government. If the intention of the Constitution were otherwise, Mr. President, Madam Chair, it would have worded the provisions accordingly, but it did not. Furthermore, through no fault of the Muslim peoples themselves, there does not seem to be any historical or cultural reason why the form of government sought to be established by the BBL should depart from what is now constitutionally mandated for the entire nation, the presidential form of government. The use of the phrase asymmetrical relationship, by which the BBL describes the link of the Bangsamoro entity to the national government, merely enhances the incompatibility with the presidential form of government for the Republic of the Philippines as mandated by the Constitution with what is proposed under the BBL. But will the assertion of an asymmetric relationship be sufficient to justify the installation of a parliamentary form of government for the Bangsamoro in lieu of the presidential form? That might need not only a judicial determination to settle, but a constitutional amendment, Madam Chair. And therefore, our proposal is, it is much better if there is time now that the wording of the BBL be changed accordingly so that it would conform with the thrust of the Constitution. Madam Chair, I would only wish to emphasize that on the reserved powers, let me point out that in Section 9 of Article 7 of the BBL, a Bangsamoro electoral code is adopted. Specifically, the code creates a Bangsamoro electoral office, which, in the words of the BBL, shall be a part of the Commission on Elections and which shall perform the functions of the Commission in the Bangsamoro. Now, whether or not the functions of the Commission on Elections are actually diminished or modified by the creation of this Bangsamoro electoral office, this has to be scrutinized very deeply by the panel, by our committee members, Madam Chair. There is also in Article 9 of the BBL the creation of the Human Rights Commission. I would suggest that it is important that the wording of that delegation of power from the Philippine Constitution to the Bangsamoro be studied very carefully. Because, particularly, Madam Chair, let me point out that in Article 9 of the Bangsamoro Law, Section 1, freedom of speech is recognized. But it stops there. It does not include freedom of the press. Now, maybe in the concept of our the framers of this law, freedom of speech already includes, freedom of the press would already include freedom of speech and vice versa. But if that is so, why did our Constitution itself say no law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for a redress of their grievances? Which means, therefore, that under our Constitution, it is the freedom of speech is treated separately from the freedom of the press. And considering what happened, Madam Chair, to Charlie Hebdo in Paris, I think it's very important that we clarify that there should also be not only freedom of speech, but also of the press in the Bangsamoro region. And finally, as a point of interest, Madam Chair, the settlement of disputes through the Sharia should clarify very clearly that when controversies entangle Muslims against Christians, Muslims against Lumads, Lumads against Lumads, or Christians against Lumads, or vice versa, national law should prevail. It is also recommended, Madam Chair, that decisions on petitions for declaration of absence or death or change of names should not be considered final, even when passed upon by the Sharia law, but should be allowed to be reviewed upon proper petition by the parties concerned, including agencies of the government. Why do we say that, Madam Chair? Because, as we very well know, recent events show that some of the perpetrators of the massacre in, where was that? Maguindanao. Some of them have disappeared, some of them have changed their names, and that will make the search for justice more difficult, Madam Chair. Basically, Madam Chair, I would like to end with this point that we bring to the attention of the committee two other issues. The apprehension of His Excellency the Sultan of Sulu, that in his view, the BBL does not clearly state whether or not the traditional jurisdiction of the Sultanate of Sulu over the Sulu Sea is recognized by the BBL, and whether or not the Sultanate's claim over Sabah is simply not a priority of the administration. Some members of the House have already spoken, Madam Chair, against the inclusion of the Sabah claim on the ground that it might only unduly prolong the implementation of the BBL. Maybe they are right, but the Sabah claim is well documented, and the sooner it is tackled by the government, the better it will be for the nation. Thank you very much, Madam Chair.
Thank you, too. Since our resource panel are eminent personalities in their respective fields, and they've reached a certain age when the minds of inferior individuals are not necessarily interesting, we would like to announce that those who have finished with their statements may, by leave of the committee, leave ahead of the rest of the proceedings. So if Justice Feliciano and Secretary Delas want to leave now, that is acceptable to the committee. But now let me go on to the next topic. The next topic actually has been given a prelude by the statements of Senator Pimentel. Checks and balances in the national government versus none in the BBL, precisely referring to the fact that the national government under the proposed bill will continue under a presidential form of government, while the Bangsamoro will operate under a parliamentary form of government. The first speaker will be former Secretary Sinan Bacani, Government Peace Panel member, and taking the opposite side will be former Supreme Court Justice Vicente Mendoza. Secretary Bacani.
Honorable Madam Chair, Honorable Senator Marcos, Honorable Senator Gingona, Honorable Senator Cayetano, other invited guests, good morning. To say that there are no checks and balances in the proposed Bangsamoro Basic Law as compared to those existing in the national government can only be due to a complete misreading of the proposed Bangsamoro Basic Law. In fact, the proposed law that will establish the framework for the future Bangsamoro government is replete with so many examples of checks and balances on the powers to be exercised by the new political entity. The proposed BBL in the first place is a classic example of trying to balance autonomy, subsidiarity, and devolution with sufficient internal controls. Overarching the whole concept of checks and balances is the fact that the President will continue to exercise general supervision over the Bangsamoro government to ensure that national laws are faithfully executed. It is worthy to note that national laws cannot be changed by the Bangsamoro Parliament unless authorized to do so by Congress. Moreover, it is clear in the proposed BBL that reserved powers, both expressed and residual, of the national government can, at any time, without any limitation, be exercised within the Bangsamoro territory. For example, the Bangsamoro government's power to enter into agreements regarding cultural exchange, technical cooperation, and economic matters is, of course, subject to central government's reserve powers over foreign affairs. In addition, the exercise of the concurrent or shared powers by the Bangsamoro government can only be done with the coordination and cooperation of the national government. To supplement the work of the constitutional bodies in the Bangsamoro, like COA, Civil Service, COMELEC, Commission on Human Rights, is the proposed establishment of auditing, civil service, election and human rights units in the Bangsamoro without prejudice, of course, to the powers, authorities, and duties of these constitutional bodies. The only goal is to assist and not, repeat, not to replace in any manner whatsoever the powers and authorities of these constitutional bodies. The Ombudsman shall continue to have the power to act on erring Bangsamoro officials. Similarly, the Supreme Court will continue to exercise the powers of supervision and judicial review over all courts, including Sharia courts. Moreover, there are clear statements in the proposed Bangsamoro Basic Law that the Bangsamoro government will have to adhere to the commitments of the national government as embodied in international treaties and agreements. The draft law also provides for additional intergovernmental bodies to be established in order to ensure cooperation and coordination between the national and Bangsamoro governments. These are, first, the central government, Bangsamoro government intergovernmental relations body to resolve issues on intergovernmental relations. Second, the Intergovernmental Fiscal Policy Board that shall address revenue imbalances and fluctuations in regional financial needs and revenue-raising capacity of the Bangsamoro. Third, the Philippine Congress Bangsamoro Parliament Forum for purposes of cooperation and coordination of legislative initiatives. Fourth, the Bangsamoro Sustainable Development Board to ensure the harmonization of environmental and development plans, as well as to formulate common environmental objectives. And fifth, the joint body for the zones of joint cooperation, which shall be responsible for drawing up policies in the zones of joint cooperation in the Sulu Sea and the Moro Gulf. Also worthy of note is the provision on the possible vote of no confidence against the government of the day, which can serve as a further check on the performance of the Bangsamoro government by the duly elected representatives of the Bangsamoro. Another is the full disclosure policy of the Bangsamoro government of its budget and finances and of bids and public offerings. Regarding public order and safety, there will be a Bangsamoro Police Board which shall perform the functions of the NAPOLCOM in the Bangsamoro. The board shall be part of the NAPOLCOM, with the NAPOLCOM ensuring that the Bangsamoro Police Board performs its powers and functions within the bounds of its authority. Above all of these controls within and outside the Bangsamoro, however, what is of paramount importance would be the demand of the governed for complete accountability of those who govern, and supported by a strong press and strong civil society organizations. That way, we can further strengthen the democratic institutions that will be established and ensure the general welfare of the people in the Bangsamoro. Therefore, Madam Chair, the proposition that there are no checks and balances in the proposed Bangsamoro Basic Law is simply not correct. Thank you for giving us the opportunity to set the record straight.
Thank you, too. And still on this same topic, the avatar of the position that there is no checks and balances in the BBL, one of the country, perhaps the country's foremost authority on constitutional law, Justice Vicente Mendoza, will give his own statement.
Thank you, Madam Chairman, Senator Marcos, Senator Gingona, Senator Pia Cayetano, and the distinguished panelists. I have prepared this statement, so what I'm just going to say now will be in the nature of answering points raised by Secretary Bacani. And maybe I will stray to other areas, but still relevant as my answers to those points raised by him. Let me state at the beginning, Madam Chairman and members of the joint committees, that my understanding of the principle of checks and balances is that it is simply a corollary of the principle of separation of powers. Without separation of powers, there can be no checks and balances. Madam Chairman, we speak of separation of powers both in the horizontal and in the perpendicular senses. When we speak of the separation of powers, as we are familiar with the principle in Philippine constitutional law, we refer to the horizontal division of powers among the legislative, executive, and judicial departments. But when you bring in the concept of perpendicular separation of powers, you are there now talking in another realm, and that is in the realm of a federal system of government. So that in the federal system of government, you have separation of powers horizontally and between or among legislative, executive, and judicial departments, and the division of power perpendicularly between the federal government and the state governments. We do not have that kind of separation of powers under the Constitution. So we do not speak of the powers of the national government vis-a-vis the forms of the local governments created in the Constitution. They do not have the status of the states in a federal union. So therefore, when you speak of the reserved powers of the president or of the national government as checks on the exclusive powers of the Bangsamoro government, you are there referring to the perpendicular power, the separation of powers, which we do not have, for the simple reason that ours is not a federal system. Ours is a presidential unitary form of government. So when we speak here of checks and balances, we refer to the checking and balancing function of the three departments: the national legislature, the national executive department, and the national judiciary. All right. Now the Constitution, Madam Chairman, as far as autonomous regions are concerned, require that they have a basic law, or rather an organic act, now called Basic Law. I think Basic Law is the Constitution in Germany. I don't know why it's not called Organic Act. Now, the Constitution, Madam Chairman, requires Congress to pass an organic law providing for the structure of government that, in the words of the Constitution, should consist of executive department and legislative assembly, both of which should be elective and representative of their constituent units. Now, this is not what is provided in the proposed BBL. What is provided there is a parliamentary system with a ministerial form of government where there is no division of power or separation of powers between the executive and the legislative department. The powers of government are vested in the parliament. The legislative function is performed by parliament. The executive functions are performed by the cabinet, but the cabinet, the majority of the members of the cabinet are members of parliament. The chief minister is elected by parliament from among its members. A majority of the members of the cabinet are required to be appointed by the chief minister from among the members of parliament. So there is no separation of powers between the lawmaking and the executive branches of that government. Therefore, there is no check and balances in the horizontal sense of, as a corollary of the horizontal separation of powers. Now, why should there be separation of powers and, as a corollary, checks and balances in the Bangsamoro government? One, because it is required by the Constitution. Second, because most of the governments the world over have only one form of government. If it is a presidential type, the local governments must also have a presidential type of government. Example, Madam Chairman, and members of the committee. Malaysia is a federation. The states composing Malaysia are parliamentary for the simple reason that the federal government is parliamentary. Take the United States of America. It's also a federal system, but its federal government, the national government, is presidential in form. So are the governments of the states of the United States presidential in form. A parliamentary form of local government, however it is called, in an otherwise presidential system is, to say the least, an oddity and anomaly. So for those two reasons, Madam Chairman, I find the proposed BBL contrary to the mandate of the Constitution. Thank you, Madam Chairman.
Thank you, Justice. Since the two sides of this particular topic have already been heard from, we are now ready to accept questions from the members of the senatorial panel. If there are none, then we'll proceed to topic 3, sovereignty versus the substate. Speaking in favor of a substate will be Professor Miriam Coronel Ferrer, Government Peace Panel Chair. And after her, the opposite side will be taken by Justice Mendoza, whom will request for additional human duties today because Dean Merlin Magallanes was suddenly taken by very high blood pressure today. Professor Ferrer.
Madam Chair, Senator Miriam Defensor Santiago, Honorable Senators Ferdinand Marcos Jr., Teofisto Gingonda III, and Pia Cayetano. I speak before you this blessed morning as a student and practitioner of politics, and less of law, as I am not a lawyer. Politics, rather than constitutional law, I believe, is the best discipline with which to approach the questions before us. Is the Bangsamoro a substate? Corollarily, is being a substate in, by, for itself, necessarily unconstitutional? Why do I say that political science relative to jurisprudence is our best recourse in getting to the heart of the matter of the Bangsamoro? We all know that matters of state are foremost matters of politics rather than law. Over and above law is the matter of peace and justice, which, to go back to the Greek classics, constitute the reason for being of the polity or of the state. Stretching forward to the Enlightenment period, peace and justice likewise are the ends of the social contract. Madam Chair, the substate word has been unjustly demonized. As in any demonized term, wave it like a red flag and people will rail against it. It is almost like the term Moro, say it, and in the minds of many, you generate fear, distrust, suspicion, hate. Such is the unfortunate state of mind that we have inherited from the Spanish and American colonial rule. Such hatred has led us to continue to think like the colonials. A good Moro is a dead Moro. Fast forward 100 to 500 years later, a good substate is a dead substate. Unconstitutional, bang, you're dead. This when in fact a substate can only mean being a subdivision of and therefore part of the state in the subnational sense, in the same way that a subset, as we learned from grade school math, can only mean being part of a bigger set. Madam Chair, the word substate is not even a legal term. It is merely a descriptive word pertaining to one part or unit of a state. How can we judge legality or illegality, constitutionality or unconstitutionality by mere mention of the word? This is not to say, however, that substates or substate entities do not exist. I have here a copy of the book, Substate Governance Through Territorial Autonomy, a comparative study in constitutional law of powers, procedures, and institutions, published in 2011, and written by the Finnish professor of comparative law and politics, Markku Suksi. Madam Chair, if I may I respectfully give you a copy, a humble contribution to your library.
We are happy to accept it.
Attorney Ana Basman will hand it over with your permission. The book provides us with a survey of sub-state entities that are of particular interest to us. These are sub-state entities that are in the form of territorial autonomous, such as one finds in countries like China, in the case of Hong Kong, Macau, and Tibet, in Finland, with Swedish-speaking Åland, Indonesia, in the case of Aceh, West Papua, and Yogyakarta. Territorial autonomies, a genre that is applicable to our case on hand, are here distinguished from federal states and obviously independent states. Madam Chair, independence was never on the negotiating agenda of the government. The whole idea of negotiation was precisely to keep the country intact. Any notion of a sub-state can only mean a setup within the Philippine state and under the Philippine Constitution. Some critics insist that the Bangsamoro in the signed documents is still the sub-state as originally conceived when we began negotiations in 2010, almost 4 years ago. They do not realize how the comprehensive agreement on the Bangsamoro for the sake of peace, national unity, and social justice had arrived at the necessary compromises in accordance with the 1987 Constitution and its flexibilities, without prejudice, of course, to future constitutional change. Now, to address a second level of the claim of unconstitutionality before us, that the Bangsamoro, being a sub-state, is not the autonomous region contemplated in the Constitution. Specifically, that the powers that have been enumerated in the signed documents and now in Senate Bill 2408 go beyond what is possible in a unitary setup. Notably, our Constitution did not explicitly say that we are a unitary state. In fact, coming from a highly centralized state under martial rule, where the executive branch was able to wield wide powers, both formally and informally, the crafters of the 1987 Constitution took pains to devolve powers through principles and provisions on local autonomy, decentralization, and autonomous regions that it encompassed in Article 10 on local governments. Moreover, and equally significant, they wrote up a whole article on social justice to correct the political, social, and cultural exclusion in our country. Markku Suksi, the author of the book, writes in the case of Europe, if states that include one or several autonomous entities are counted together with the number of federal states, the result, at least in Europe, is that the regular textbook example of state, the entirely monolithic unitary state, finds itself in a minority and is no longer the prime example of a state. Evidently, there are so many existing possibilities to structure a relationship, horizontal, perpendicular, between government and its multiple constituencies that a binary system of political ordering, either a federal or unitary state, can no longer accommodate. The members of the Constitutional Commission in 1986 grappled with adopting a federal system of government. But in the end, they settled for this unique animal. So unique, it may be set up in only two parts of the country, in the Cordillera and in Muslim Mindanao. They called this animal autonomous region. In so doing, they also produce a model that is distinct but also finds a semblance in other non-federal republics, such as Indonesia, with its 3 autonomous regions, China with its 3 special administrative regions that I mentioned earlier, but also Spain with its more than 10 autonomous regions, and the United Kingdom with its 4 constituent parts, the most appropriate term for which has not been found. These constituent parts are Northern Ireland, Wales, Scotland, and England. All these are variations of that much derided, although affably neutral and practical generic word called substate. Regardless, other critics say that the structure of government and the powers enumerated in the power sharing and wealth sharing annexes, and now the BBL, the draft BBL, partake of the nature of a federal state. Proof to such claim is the concept introduced in the documents of an asymmetrical relationship between the Bangsamoro and the central government. To the Supreme Court's credit, we have recently been provided with jurisprudence on what asymmetry means. In the League of Provinces of the Philippines and the DNR versus the DNR, the Supreme Court ruled, and I quote, "Autonomous regions are granted more powers and less intervention from the national government than territorial and political subdivisions. They are thus in a more asymmetrical relationship with the national government compared to other local governments or any regional formation. The Constitution grants them legislative powers over matters," enumerating the provisions in the Constitution, and continuing with the statement, "that are usually under the control of the national government," unquote. While the ruling did not define asymmetry, it provides us with the context clues by which we can understand the concept within constitutional boundaries. Another claim put forward to argue violation of the Constitution is the list of powers enumerated in the draft BBL, reserved, concurrent, and exclusive. Reserved powers are powers or matters over which authority and jurisdiction are retained by the central government. Concurrent powers shall refer to the shared powers between the central government and the Bangsamoro government. Exclusive powers shall refer to powers or matters over which authority and jurisdiction pertain to the Bangsamoro government. Is there anything in this definition and the list of powers that violate the Constitution? Does the granting of exclusive powers to the Bangsamoro affects its separation from the state? I use the word separation here in the first context that was used earlier by Justice Mendoza in the perpendicular context. Not so in many ways. Exclusive powers which are exercised within the Bangsamoro territorial jurisdiction may be clipped by the reserved powers of the central government which are exercised in the whole country, including the Bangsamoro. Reserved powers, to repeat, are exercised in the whole country, including the Bangsamoro. Indeed, Justice Mendoza is right. There is no separation of power in the first context that he used the term, as indeed we are not establishing a federal state. We are establishing an autonomous region that continues to be part and parcel in that kind of horizontal relationship vis-a-vis the central government. To be more specific, or to cite some examples, regulation of trade, banking, and finance, the Bangsamoro may have been, the regulation of these items may have been devolved, but this matter is governed by national fiscal and monetary policies, foreign treaties and conventions our country has entered into, foreign policy, customs, and tariff laws, all reserved powers of the central government. In case of conflict of laws, as Senator Pimentel mentioned earlier, it's evident that national laws and the Constitution shall prevail. And in case there is conflict in the interpretation of such laws, then there is always the recourse to the Supreme Court. Clipping of the powers of the Bangsamoro can very well be effected by these reserved powers, not only as enumerated in the BBL, but in the totality of central government powers, as well as that of the Supreme Court, Congress, and the constitutional bodies that we find in the Constitution. But then, what we envision here is a democratic relationship based on mutual respect or parity of esteem as public officials and leaders vested with their respective authorities. Moreover, when the exercise of the Bangsamoro government's powers impacts outside of the territorial jurisdiction of the Bangsamoro, it is understood that the neighboring local government units with powers that have been given to them by the local government code and the central government can take the appropriate action, again, based on their respective powers in accordance with the appropriate laws. This is fairly well understood in that the President, as provided for in the Constitution, shall exercise general supervisory powers over the autonomous region, as provided in Article 10, Section 16 of the Constitution, and reiterated in Article 6, Section 3 of the Senate Bill. The President shall exercise general supervision over autonomous regions to ensure that the laws are faithfully executed. Finally, the Constitution itself grants the parameters for the autonomous jurisdiction of the autonomous regions when it said that these regions shall have the following legislative powers, subject, of course, to the Constitution and national laws, although existing national laws shall be qualified by the forthcoming Bangsamoro Basic Law, insofar as the Bangsamoro is concerned, as in the nature of a more recent national law, but of special application. Article 10, Section 20, according to the Constitution, within its territorial jurisdiction and subject to the provisions of this Constitution and national laws, the Organic Act of Autonomous Regions, the draft BBL, shall provide for legislative powers over the following: administrative organization, creation of sources of revenues, therefore the slew of taxing powers that we are giving to the we propose to give to the Bangsamoro, ancestral domain and natural resources, therefore a set of concurrent powers and exclusive powers over matters having to do with the environmental protection, mining, and energy that are properly defined in the different sections of the Senate bill. Personal and family and property relations, and therefore the special application of Sharia law in this region where you have more than 90% of the population Muslims. Regional, urban, and rural planning development, economic, social, and tourism development, educational policies, preservation and development of the cultural heritage, and such other matters as may be authorized by law, including this Senate bill that we hope to be passed in the form of the Bangsamoro Basic Law for the promotion of the general welfare of the people of the region. All so-called exclusive powers listed in the annex on power sharing and now the draft BBL fall under any of these category, not to mention the fairly encompassing category of matters for the promotion of the general welfare of the people in the region. All powers shall not prejudice the powers and authority of constitutional bodies, the Supreme Court and Congress. If certain provisions may have been given rise to such misinterpretation, then certainly we can improve and fine-tune the languaging. Truth to tell, many of these powers actually were already given to the arm. However, many of these powers, for example, the power to enact its own Indigenous Peoples' Rights Act and Civil Service Code, and to expand Sharia courts, including appellate courts, were never exercised by the arm, even though, in fact, these are already provided for by Republic Act 9054. To say that giving such powers as one now finds in the BBL compromises the sovereignty of the state is to deny the powers which the Constitution itself allocates to the autonomous regions. Madam Chair, remember, sovereignty is not just about our standing before other states and relations with them, a matter that remains in the hands of national government. Sovereignty is first and foremost the exercise of the people's will, and the people's will operates at different territorial and political subdivisions of the state, including autonomous regions, and that is why we have local and regional plebiscites, as well as our law on initiatives and recall. Modern political and legal thinking on devolution, decentralization, and autonomy, and the right to self-determination not only of colonies, but of indigenous peoples and minorities, are all pointing in this direction of a multi-layered sovereignty within states, as we can glean from these quotations from authoritative sources. Quote, sovereignty, like the atom, can be split, unquote. Another quote, in modern times, sovereignty is divisible. Indeed, Madam Chair, the world has changed much since the Peace of Westphalia was forged in the 17th century with its emphasis on state sovereignty. We credit the framers of our Constitution, and we have before us two members of the 1987 Constitutional Commission, retired Justice Ascuna and Commissioner Chito Gascon, who was also a member of our panel. We credit them in finding the balance between the sovereignty of the Philippine state and the sovereignty of the people of the Philippines. We thank them for showing us the manner by which such sovereignty may be shared among the various peoples and groups making up the Philippine Republic. And among these groups of people, among the Filipinos, as we know, are the Bangsamoro. Let us give them their due, even as we ensure the protection of rights and promotion of welfare of all that will fall under the territorial jurisdiction of the Bangsamoro. Towards these ends, we have noted the specific proposals that we have heard, not only in this consultation, but in other consultations, and we believe that they will enhance the viability of the Bangsamoro Basic Law. Thank you very much, Madam Chair.
Thank you, Professor Ferrer. The other side would have been aired by Dean Magallona, but he was suddenly stricken, and we request Justice Mendoza to gallantly step in and complete the debate on this particular topic. And furthermore, I'm afraid we will have no more time for the fourth topic. So next Monday, which is our second and last hearing, we will request the following resource persons present today, with our apologies, to come again. Commissioner Gascon, Justice Ascuna, just those two. We will request you to come again for the hearing on Monday, February 2, plus Dean, where? We request further the third person to come back, Dean Julkipli Wadi of the UP Institute of Islamic Studies. Is he for or against? Joining them will be former Senator Rene Sagisag. And against them, also by topic, will be the following: the CBCP, the Catholic Bishops' Conference of the Philippines, which has issued a statement, just a bare statement, that it is against BBL because of the question of territorial integrity, which they hope to expatiate on next Monday. So there will be the CBCP, Dean Aquino of San Beda, who cannot come today because he has to give a lecture in Baguio City, the Philconsa, which just issued today a statement against the BBL, and Dean Magallona, if he is well enough. So we will have those resource persons next Monday. In the meantime, we'll call again on Justice Mendoza.
Members of the distinguished members of the committee. There are just too many terms that are new. Of course, I know that law must change with the times, but Madam Chairman, change is not the only feature of a dynamic law. It is also conservation of what has been taken. So what we strive, in particular, in my case, what I strive for is for continuity amidst change. Madam Chairman, but I simply cannot find in the literature anything about a substate, and it's not in the Constitution, or anything about asymmetric relation, except as this is defined in the BBL. So within this, considering this, I'd like to begin by saying, whatever the Bangsamoro government is called, a substate or anything else, it is not one of the forms of local government authorized in the Constitution, namely the provinces, the cities, the municipalities, the barangays, and the autonomous regions. It is none of this, and I submit that Congress cannot enact a law providing for any other form of local government. That, in brief, is our position, Madam Chairman. Let me begin with this discussion on the asymmetric relation given as a justification for not applying to the BBL the provisions of the Constitution. Under the Constitution, as I already said, the only forms of local governments are the provinces, the cities, the municipalities, and the barangays, and the two autonomous regions in Muslim Mindanao and the Cordilleras. But Article 6, Section 1 of the BBL states that the Bangsamoro is distinct from other regions and other local governments. This implies that it is none of these forms of government provided in the Constitution. And the question is, can Congress do that? What is the Bangsamoro if it is not one of these? It is what I would say similar to the status of the Commonwealth government before the grant of independence in 1946. As the United States Supreme Court noted, the Commonwealth government was a sovereign government because the U.S. Congress, little by little or step by step, granted greater autonomy and powers to the Commonwealth government, retaining only what was necessary to check its ascendancy. The Bangsamoro government is similar to that. It is similar to the trust territories under the United Nations Charter, which were given a large amount of autonomy in preparation for the grant of independence to them. But we have just been told by Chairman Coronel Ferrer that the word independence cannot be found in the BBL. Of course, it is not in the BBL, otherwise that would spell the doom of that bill. But although the word independence is not there, it is studiously avoided to provide the equivalent of independence. In those instances where independence cannot be justified, the principle of asymmetrical relationship and subsidiarity are invoked. To say that the Bangsamoro government's relation to the central government cannot be similar to the government of the existing local governments in the Constitution is to beg the question. Because the Constitution very clearly says that the government shall be created, the Bangsamoro government shall be created within the framework of the Constitution and national sovereignty as well as territorial integrity of the Republic of the Philippines. And number two, that any power delegated to the Bangsamoro government shall be subject to the provisions of the Constitution and the national laws. Indeed, the limitation that anything Congress does in creating or granting powers to autonomous regions must be subject to the Constitution and the national laws, and that is clear for anyone not to hear or not to see. Otherwise, if Congress can ignore such limitations by simply declaring that the political entity it creates is distinct from other regions and other local governments, and therefore you cannot compare them to those in the BBL, then to that extent, Madam Chairman, Congress is actually rewriting the Constitution. Now let me be more specific. I have already discussed the form of government which I say is contrary to what the Constitution requires. A parliamentary system is being prescribed in the BBL, contrary to the plain mandate of the Constitution that the government for the autonomous regions must have a presidential form of government, in effect, by requiring that the executive department and the National Assembly should be separate and elected and representative of the constituent units. So I'll not dwell anything more on that. Number two, you have here a definition of who are Bangsamoros. It sounds like the definition of who are citizens of the Philippines. By defining of who are to be considered Bangsamoros, the BBL, in effect, gives the Bangsamoro Parliament the power to pass a law, such as the Electoral Code, which it is authorized to pass, limiting suffrage and membership in the Bangsamoro government to the Bangsamoro people, thereby denying the rights and privileges of national citizenship as guaranteed in the Constitution to others. The result would be non-Bangsamoros, although Filipino citizens and residents of the region for a requisite period, can be disqualified from election to public offices in the provinces, cities, municipalities, barangays, and other areas in the Bangsamoro territory. This is because the definition of the bill of who are considered Bangsamoros performs the same function that the definition of who are citizens of a nation or a state does in a national constitution, namely to screen out outsiders from certain privileges of national life. Powers of government. As Justice Feliciano noted, there is a lopsided division of powers between the national government and the Bangsamoro. Only 8 reserved powers to the national government, 48 to the exclusive powers to the Bangsamoro. What results from this is that the powers of the national government are limited to those that are called reserved, and there are very few of them. The rest of the powers of government are given to the Bangsamoro, so that instead of possessing the residual powers after giving some to the Bangsamoro government, the BBL reverses that and says that whatever has not been given to the national government, and there are only 8 or 9 powers given to the national government, the balance, the rest of the powers of sovereignty should be given to the Bangsamoro, with certain powers in between called concurrent powers shared by the 2 governments. Now that's a dangerous tinkering with the allocation of powers between national and local government, Madam Chairman. Local governments are simply agencies of governmental powers. Of course, they've been granted autonomy through the years, culminating in the recognition of autonomous regions because of the differences in their history, their culture, their social and economic structures, but to also recognize that they have to be respected with respect to their political structures would be diminishing the sovereignty of the Philippines as a state. I do not speak of the sovereignty of government alone or of the sovereignty of the people. Sovereignty is a whole absolute power, and under the Constitution, while it resides in the people as a whole, all the Filipinos, size of that is mostly granted to the government, except in elections and amendments of the Constitution. Now, Madam Chairman, may I take a few more minutes, Madam Chairman, to round out?
Of course.
The problem is, some of these powers that the BBL proposes to give the Bangsamoro government are not legislative, but constituent powers. Powers to amend the Constitution. But Article 10, Section 20, authorizing Congress to delegate powers to the autonomous governments, is very clear. Only legislative powers. That's very clear in Section 20, Madam Chairman. And of course, what can Congress delegate? Congress can delegate only the powers granted to it by the Constitution, and they are mostly legislative. Those are the powers that can be granted, the only powers that can be granted by Congress to the Bangsamoro. But the proposed BBL grants them more than this. In the words of the 2008 MOA-AD decision, BBL is a state in all but its form. It possesses a territory zealously defined and declared to be the birthright of the Bangsamoro people as defined in the Bangsamoro. The people who are going to be occupying the territory, constituting the territory, are defined, and they are called Bangsamoro. It has a government, parliamentary in form, and possessing more powers with respect to affairs of that region than the national government. It even has limited powers over foreign relations. It can contract loans. It can trade with ASEANs. It can receive donations from foreign sources. And we know, Madam Chairman, that loans carry with them certain conditionalities. So what are these? These are attributes of a state. What is simply lacking is, or probably more powers over foreign affairs. Otherwise, it is a state. Add to this the declaration that the people have the right of self-determination. Well, as used in the United Nations charters and other documents of the United Nations, self-determination does not mean external self-determination. It has been recognized to be cabined and limited by a respect for the existing government and has been limited to autonomy with respect to the local matters, but never external powers that could lead to secession. Now, it is said that the President, just the same, exercises general supervision over the autonomous government. That is what the Constitution provides, but in the proposed BBL, it is not only general supervision, already a very, very watered-down concept, still qualified by the phrase that the President's general supervision shall be subject to the principle of autonomy and, again, the word asymmetric relation of the Bangsamoro government to the central government. Now, this contrasts strikingly with the proposed with respect to the supervision over the wali. The Constitution, the BBL says the President also has general supervision over the wali. But unlike general supervision over the Bangsamoro government, the President's general supervision is unqualified. But of course, Madam Chairman, the wali has no powers, mostly ceremonial and to dissolve the parliament, that's all. So that supervision there will probably be meaningless as far as the powers of the government, national government, are concerned. Now, all of these powers that I said raise some spatial concern are constitutional problems. Beyond the power of Congress to exercise, if Bangsamoro is to be created as the prize for peace in Mindanao, it must be by the will of the Filipino people as a whole, not solely the will of the Bangsamoro people living in the Bangsamoro territory, and it must be by constitutional amendment and not by an act of Congress. Senator Gingona was asking whether the proposed BBL cannot be considered a proposal to amend the Constitution. And this Congress, sitting as a constituent assembly to propose amendment to the Constitution and to consider the voice of the people expressed in some referenda in the provinces as sufficient. The constituent power, considering the importance of the subject, must be exercised strictly in accordance with the procedure of Article 17, which means that Congress should sit together as a constituent assembly and make a proposal. Madam Chairman, this is too important to be disregarded and informally considered. We have got to follow the form and the procedure in Article 17 if we are to pass these features of the bill as proposals for a constitutional amendment or revision. I think it will be a revision to be technical. And then submitted to the people in a plebiscite within a period from 60 to 90 days. And all that is required in order to amend or revise the Constitution. Short of that, Madam Chairman, the BBL cannot be passed by Congress either as a proposal to amend the Constitution. It is noteworthy, Madam Chairman, that in the framework agreement between the peace panels of the Philippine government and the MILF, the creation of a transition commission was provided for, the task of which was to draft a basic law and to work on proposals to amend the Constitution for the purpose of accommodating and entrenching in the Constitution the agreement of the parties whenever necessary without derogating from any prior peace agreement. However, only the draft Bangsamoro Basic Agreement was submitted by the Transition Commission. Why no proposals for constitutional amendments were also prepared has not been explained. But whatever may be the reason for the absence of such proposals, implicit in the assignment of the Transition Commission to draft such amendments is an acknowledgement by the parties to the comprehensive agreement that the essential provisions of the agreements which were to be embodied in the basic law were incompatible with the provisions of the Constitution, hence the need to amend the Constitution to obviate the constitutional objections before the basic law may be considered. Thank you, Madam Chairman.
Thank you very much, Justice Mendoza. Now, are there any questions? Otherwise, with deep gratitude to all who came today to constitute a resource panel. Oh, yes. Professor Ferrer.
In the indulgence, Madam Chair, may I just make some statements of facts with regard to
All right.
what former Justice Mendoza has said today?
It's not going to be very lengthy.
No, just
Thank you.
some kind of factual statements.
Please proceed.
On the matter of residual powers, it is not the case that the draft law says that the residual powers now belong to the Bangsamoro government. There is nothing in the draft law that transfers the residual powers provided for in the Constitution specifically given to the central government. And I think that is a very important qualification because it implies that the listing of reserve powers is incomplete in itself. It is not the totality of all the powers that are exercised by the central government, and certainly does not even include the powers of Congress, the Supreme Court, and all the other constitutional bodies. That's just a factual statement. On the statement of the Bangsamoro identity being equivalent to citizenship, we beg to disagree on that matter. Each one of us has our own identities based on ethnicity or maybe even religion, but it does not mean that identity is equivalent to citizenship. What is provided for in the Bangsamoro Basic Law is acknowledgement of a right to a certain identity in the same way that we take as a matter of ordinariness that we may be Ilocanos and we may be Kapampangans, but we are all Filipino citizens. On the matter of legislative powers as the only ones that are being granted to the autonomous region, it is the case, Your Honor, as far as I understand, legislative powers is precisely the power to legislate, meaning that as you legislate, you can actually create offices, that you can define functions and responsibilities, and all the other elements that will be needed to exercise proper jurisdiction in accordance with the powers that are provided in the law. Therefore, legislative powers are not in themselves or nor for themselves, but they are precisely there to be able to exercise all the other relevant powers that are befitting an autonomous region. That is all, Madam Chair.
Thank you. These clarifications as rebuttal are well taken. We request Mr. Gascon, Ascuna, and Wadi to come next Monday, February 2, also at 10 o'clock in these premises, so we can continue our hearing. Thank you very much. This meeting is adjourned. Media, will you please come forward? Uy, mag-stay kayo.
I have a 12 and then I have a 1 o'clock hearing.
Wow, busy lady, ah.
Oh, are you? Oh, you're so warm.
The best cure for your situation is to get a boyfriend as soon as possible. Anyone will do.
Really?
Oh, takip lang naman sila eh.
Chief of staff yan. Sabi niya, the best cure for my situation. And what is my situation? Just being alone.
Well, nothing materialized out of that relationship.
Yeah, wala na yun.
Right. The best situation.